Howell, who appears in person to my right.
All right, good morning. We're here for an arraignment and also a bond matter that was sent up from the district court. So for purposes of just arraignment, do you and your client waive the reading of the information?
Yes, we would, Judge. We would waive formal reading of both her rights and the charges at this time.
Okay, and is a forensic center referral requested?
No, Your Honor.
I see in front of me a a plea agreement to count one with the habitual third being dismissed.
That is correct.
All right, and Ms. Howell, is that how you want to proceed today?
Yes, Your Honor.
Okay. Would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can have a seat. Are you Joy Ann Howell?
Yes, I am.
Ms. Howell, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have any questions, just ask me. I'm happy to answer them. If you need more time to talk to your attorney, you just let me know. We're happy to give you that time. Do you understand that? All right. Now, I have to advise you the maximum penalty that you could face for the charge of operating while intoxicated third offense. It is a felony crime. It's punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation with 30 days to a year in the county jail, at least 48 hours to be served consecutively, and 60 to 180 days community service. The court can order rehabilitative programs, costs of prosecution and emergency response, and vehicle immobilization. Do you understand the maximum penalty?
Yes, I do.
Are you on probation or parole anywhere?
No.
Were you on bond for any other cases at the time of this incident?
No, Your Honor.
Did you read and understand the rights listed on the advice of rights form?
Yes, I did.
And you
Your
signed
Honor.
that form today?
Yeah.
Do you have any questions for me or Mr. Nightingale about any of the rights listed on that form?
No, Your Honor.
Do you understand that if you enter a plea, you give up all those rights and will not have a trial?
Yes, I do, Your Honor.
And is that what you are choosing to do today?
Yes, I do, Your Honor.
If I accept your plea, you give up any claim that that plea was caused by threats or by promises that aren't put on the record today. Do you understand that?
Yes, I do.
Also, when you enter a guilty plea, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission to do so, which you would do by filing an application. But the types of issues that you can raise on appeal after a plea are very limited, much more limited than if you were convicted after a trial. Do you understand this?
Yes, I do.
The plea agreement provides, in exchange for a plea to count one, the operating while intoxicated third offense, there's an OWI reimbursement agreed by the parties at $62.12, and the prosecutors agreed to dismiss the habitual third. Do you understand the terms of that plea agreement?
Yes, I do, Your Honor.
Mr. Nightingale, is that a full, fair, and accurate statement of its terms?
It is, Your Honor. Thank you.
Ms. Cooper?
Yes.
Ms. Howell, other than that plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to enter this plea?
Yes, I do, Your Honor.
Knowing all this, how do you wish to plead to the charge of operating while intoxicated third offense?
Guilty, Your Honor.
So, Ms. Howell, back on August 26th of 2025, were you in Sheboygan County?
Yes, I was.
Were you operating a motor vehicle on M68, a public highway?
Yes, I was.
Before you operated that motor vehicle, did you consume alcoholic beverages?
The night before.
The night before. And did you have some contact with law enforcement? With
That
police?
morning I did.
That morning? Okay, after you were driving the car, you had contact with law enforcement? And did they give you a test to determine the amount of alcohol in your body?
Yes, they did.
Do you remember the results of that
I
test?
think it was 0.9.
A
I believe. it was.
0.09?
All right.
Okay.
Oh, yeah.
And that's
0.09.
above the legal limit of the 0.08 then?
Correct.
Okay. And at that time, did you have a previous conviction for operating with an unlawful bodily alcohol level in 1994 in the 41st B District Court?
Yes, I did.
And also operating while intoxicated second offense in 1995 in the same court, 41B,
Yes, I did.
2002 in the 41A,
Yes.
and an OWI 2 in 2004 in the 41st A.
Yes.
All right, Mr. Nightingale, you satisfied with that factual basis?
I am, Your Honor, and just to be clear, the breath test was a .095.
Okay.
Don't want to mislead the court anymore.
Okay, Ms. Goodrich, you satisfied with that factual basis?
Yes.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
No.
Ms. Goodrich?
No, Your Honor.
And Mr. Nightingale, in your judgment, has the court fully complied with the requirements of MCR 6.302?
The court has.
Ms. Goodrich?
Yes.
All right, Ms. Howell, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept the plea. We could schedule sentencing for the morning of July 7th, Mr. Nightingale.
If I could just verify that date.
Okay.
Oh, that was giving me things, Judge.
Okay, we'll do July 7th at 10:10 in the morning. Have to cooperate with a pre-sentence investigation report and interview. I do want to address what counsel also sent up from the bind over was from the district court, a bond violation hearing. And then since that time, we've had another missed test and another dilute test. So I guess I wanted to find out how we're proceeding on the bond violation hearing today. Mr. Nightingale.
Can the court tell me when the allegation of the mistest was?
Yeah, so let's see. What I have from the district court was you have all those, right?
I believe so, yes.
Okay. Those were from the district court. It said there was a missed test August 29th, September 3rd, dilute test October 15th, missed test October 30th, missed test October 17th, dilute test November 11th, dilute test December 11th, December 26th, and December 31st. And then the case, then the case was bound over. And since then, on September 18th, we have a missed test. And then on April 16th, I have a dilute test. And then, okay, yeah, the one that I was handed today was something back in October. Okay. Okay.
The mistest was from September.
Well, I've got, somebody just handed me along with the plea agreement. I think this came from you, judge's copy
Yes.
for a delete back in October. October.
I gave the court a screens that she had taken the screens from the 10:30 and 11:07.
Yes.
Those were the two that were passed up. I just want to make sure that there wasn't any other mistest besides August 29th and September 3rd. I was aware of those. But.
Yeah. February 18th, since bind over, a missed test, and April 16th, a dilute test. I guess, I mean, well, here's the question. I mean, you know, regardless of any pending contempt that's out there, this is a true sixth, and that's just a remarkably bad record on bond. I mean, I have full intentions of canceling her bond today. Even if she hadn't entered the plea, I was going to be having a conversation about that. So I'd like to hear any reason why I should not be canceling her bond right now.
Judge, I was going to state today, obviously, that I had provided proof that she had attended both October 30th and November 7th. Those same documents were provided to the court and the prosecuting attorney down in district court before bind over.
It's not as helpful as you think, because one of them is dilute.
I understand, but at the end of the day, you know, she is still complying, right? And I think that
I'm not sure I'd call a series of dilutes complying, right?
reasonable minds can disagree.
Well, okay, you're required as a condition of bond to give a valid urine sample, and the dilute is not valid.
I understand that, Judge. You know, I think part of Ms. Howell's issue is that, just medically speaking, she has an issue providing a sample without hydrating appropriately, and she balances a very fine line of potentially hydrating too much sometimes. it is difficult for her to provide this, as I said. So I think the court should know that when she was first put on bond in the district court, she was put on the scram tether. She wore that for a period of a few days, and it caused a giant lesion in her leg. And so that was removed. She was then placed on or continued on this random testing, the drug line testing. And I guess to my knowledge, has had no true positives. I understand the court will consider dilutes positive tests, but I would always argue that it's not the same. And so she has had not a single, to my knowledge, true positive test, has maintained good communication with me, is actively engaged in treatment, has gotten assessment through Harbor Hall. We were trying to get her into recovery court about every county in the state of Michigan, and it just didn't work. So we're asking to leave her out of custody today and have her come back for sentencing. I understand the court's inclination.
All right, she just
admitted to her sixth time being convicted of drunk driving. This is the moment everything changes. Watch the courtroom carefully, because the judge is seconds away from making a decision that nobody in that room can avoid.
Admitted to her sixth time being convicted of drunk driving. I've got a spotty enough record on bond. We'll continue the status conference on the pending violations to the sentencing date. But she, especially now, she's no longer cloaked with the presumption of innocence. Bond is entirely discretionary with the court. I don't see any reason why I should continue her on bond, or she'll be remanded to the custody of the Sheboygan County Sheriff until sentencing.
Thank you.
Oh, this is Kozlowski. All right, I also have Mr. Braden Freeman on the docket, but he's in Grand Traverse County and they haven't zoomed in yet. So we'll pass that case. Right, he's still in Grand Traverse County Jail?
To my knowledge, yes.
Okay. So to bring us then to People v. Larissa Sayers, 26-7163 FH. Counsel, you want to state your appearances for the record, please?
Prosecutors, go ahead, prosecutor. Liz Elliott on behalf of Larissa Sayers, who's joined today at council table to my right.
All right, and it's the time and date set for a sentencing, and also it looks like a bond violation arraignment sent up from district court pre-bind over. For purposes of arraignment, Ms. Elliott, have you had a chance to review the charging document with your client?
Yes, Your Honor.
And do you or she wish to have the allegations formally read?
No, we would waive that.
And does she wish to plead to that charge?
We have a plea offer, Your Honor. Mr.
Okay.
Nightingale went to go grab my file. I left it sitting on my desk.
Okay. Is a forensic center referral requested?
No.
Well, let's proceed then with the show cause arraignment. Ms. Sayers, it's alleged that you failed to comply with conditions of your bond, having a positive BAC on April 13th. Readings of a 0.016, 0.010, 0.008, 0.006. Looks like on the sober link, yeah, going down. You have the right to have a hearing in the assistance of counsel and present evidence in your own defense. Questioning the witnesses presented against you. Your contempt need to be proven beyond a reasonable doubt. If I find you in contempt, I can jail you for up to 93 days or fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. Do you understand the rights that you have and the penalties involved?
Yes, sir.
And Ms. Elliott, do you know how she wishes to proceed on that bond violation?
I'm not guilty, plea, Your Honor.
You want her to plead not guilty on the contempt here. And we are entering a plea then?
Yes, Your Honor.
Yes. Council approach, please. All right, so we're back on the record, and Ms. Sayers, I wanted to talk with your attorney and the prosecutor. This has a 30-day jail cap, and I'm a little bit worried about that, this being your fourth and the bond issue too. So wanted to talk about that a little bit. Would you go ahead and please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. Are you Larissa May Sayers?
Yes.
Sayers, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, go ahead and ask me. If you need more time to talk to your attorney, you just say so, okay? I have to advise you the maximum penalty that you could face for the charge. Operating while intoxicated, third offense is a felony punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation with 30 days to a year in jail, at least 48 hours to be served consecutively, and 60 to 180 days community service. The court can order rehabilitative programs, cross prosecution and emergency response, and vehicle immobilization. Count 2 is operating on a suspended driver's license. It's a misdemeanor punishable by 93 days and or a $500 fine and vehicle immobilization. Do you understand the maximum penalties involved? And do you understand if you, I'm sorry, are you on probation or parole anywhere? Okay. Were you on bond for any other case at the time of this incident? Do you understand if you plead guilty, you won't have a trial of any kind and you'll be giving up the rights you would have had at trial? I want to remind you of some of the more important of those trial rights. You'd have the right to be tried by a judge or jury and at that trial to be presumed innocent unless or and until the prosecutor proved you guilt beyond a reasonable doubt. Do you understand that? You have to speak up so we can make a record. Okay. At that trial, you'd also have the right to have the witnesses against you appear and you could question them. You'd have the right to present witnesses in your own defense and have me order those folks to show up. Do you understand those rights?
Yes.
And at that trial, you'd have the right either to testify in your own defense or to remain silent and not have your silence used against you. Do you understand those rights? Do you wish to give up those rights and enter a plea here today?
Yes.
Okay. If I accept your plea, you give up any claim that the plea was caused by threats or by any promises that aren't put on the record today. Do you understand that?
Yes.
Also, when you enter a plea, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. But the types of issues you could raise on an appeal by application are very limited, much more limited than if you were convicted after a trial. Do you understand that? You have to speak up so we make a record.
Yes.
Okay. You work in DOC? I know you got an outside voice.
Yes.
So, okay, there we go. All right. This plea agreement provides in exchange for your plea to those charges, there's a $225 OWI reimbursement to the Sheriff's Department, and there's a sentence agreement for a 30-day cap. Do you understand the terms of that agreement?
Yes, sir.
Now, I'm not required to follow that sentence agreement. If at the sentencing, I'm going to know more about you at the sentencing with a pre-sentence report. And if I don't want to be limited to that 30-day cap, I don't have to be. But if I gave you more than those 30 days, you'd be given an option to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, sir.
Now, that's unless you engage in some misconduct between now and the sentencing, either not showing up for court, absconding or forfeiting your bond, violating conditions of your bond, or committing a new crime. Conduct of that nature would cause you to lose the right to withdraw your plea, even if I went beyond the sentence agreement. Do you understand that?
Yes, Your
Other than the plea agreement, has anybody promised you anything to get you to plead guilty today?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead the charge of operating while intoxicated third offense? And how do you wish to plead to the charge of operating on a suspended driver's license?
Guilty.
So Ms. Sayers, back on December 27th of 2025, were you in Sheboygan County?
Yes, sir.
Were you operating a motor vehicle on a public highway, that being Man Road?
Yes.
Did you have a suspended or revoked driver's license?
Yes, Your Honor.
And you knew that it was suspended or revoked?
Yes, Your Honor.
And before you'd operated that vehicle on that public highway, had you consumed alcoholic beverages?
Yes, Your Honor.
Did you have some contact with law enforcement?
Yes.
And did they give you a test to determine the amount of alcohol in your body?
Yes, it is.
Do you remember what the results of that test were?
I want to say it was 0.14.
Okay. And you agree that that's higher than the legal limit in the state of Michigan? And at that time, did you have a previous conviction for operating while intoxicated in the 89th District Court in 2016?
That's right.
And operating under the influence in 2003 in the 89th District Court?
That's right.
And operating impaired in 2001 in the 89th District Court?
Yes,
All right. Ms. Elliott, you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Ms. Elliott, are you aware of any other promises, threats, or inducements?
No.
Ms. Goodrich?
No, Your Honor.
And Ms. Elliott, in your judgment, has the court fully complied with the requirements of MCR 6.02?
It has.
Ms. Goodrich?
Yes.
All right, Ms. Sayers, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you guilty by offense. So I hereby accept your plea. We can schedule sentencing for July 7. At 10:50 in the morning. Oops. You'll have to cooperate with a pre-sentence interview and report. We'll continue the pending contempt for a status conference on the same date and time. But I think I don't want you to tell me anything about that because you've pled not guilty and we've put that out for a hearing. But just to tell you that, you know, if I fell off the turnip truck yesterday, maybe I'm a quick learner. And I understand looking at those SoberLink readings in the morning, I understand what was happening. Okay. So what I want to do for your own safety and the public's is amend your bond at this time to require you within 48 hours to switch out that SoberLink for an alcohol tether on your ankle. And also your attorney, I'm sure, has explained to you or will that, as I just told you, if there's positive readings on that between now and the sentencing, that 30-day cap goes out the window and you don't get to withdraw your plea.
Yes.
So what I want to tell you about that is one more thing. If you find that you are having trouble not drinking right now, this would be the time for you to let your attorney know that so that we can come up with a treatment plan for you instead of just waiting to catch you violate. Okay. All right, so we'll amend it to alcohol tether in 48 hours. All right, and with that, I'll continue the bond though. Anything further from the defense?
No, Your Honor. Thank you.
Anything further from the people?
No, Your Honor. Thank you.
Okay, we'll see you then, Ms. Sayers. All right, and then this is Mr. Moxlow. Oh, I'm sorry, this is Mr. Kozlowski. All right, let's call, is Mr. Nightingale still around? Okay. Oh, okay.
Do we need to get him, Your Honor?
All right. So, we'll amend it to you alcohol tether in 48 hours. And just like that, the courtroom mood completely shifted. One defendant lost her bond, another got a final warning, and the judge made one thing painfully clear: patience runs out eventually. Justice doesn't always come fast, but when it does, it hits hard.